All right, we're cause number 253-7045, State of Texas versus Emma Lynch. Ms. Lynch was picked up at DWI November 4th of 2024. She was ordered not to consume alcohol or illegal drugs. We now have a bond violation report. Today's date is February 3rd, 2025. Can you please identify yourselves for purposes of the record?
For the state, Kelsey Siegler. Anna Edie for Ms. Lynch.
Okay. So Ms. Lynch was...
You can already feel the tension building in the courtroom. 2 bond violations in just a few months. That's not a good sign. In situations like this, repeat violations send a clear message to the judge. The defendant can't follow orders. When that realization hits, the atmosphere in the room changes. Everyone can sense a possible bond revocation coming. What do you think? Should judges give repeat violators another chance, or is it game over once trust is broken?
Here now, again, this also is a second bond violation report. The first violation was November 20th of 24. We now have another bond violation. It is a report that was filed on the 29th. Okay, State, if you'd like to.
There is slow, if you can just give me a moment, but this case is regarding this similar, not of skipping testing as well. And I'm trying to print the bond violation report and the bond conditions, just one moment. But we would call as our witness, pretrial services, Felicia Giles, again.
Okay. Ma'am, would you come on up? Would you raise your right hand? Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Okay, please.
Thank you, Ms. Giles. Are you able to show us the bond conditions on your end, if you have them on your?
Yes, would you like me to?
Yes, ma'am. Thank you. And Your Honor, we would like, if you could please take judicial notice of the file as well here regarding
Sure.
the
Any
defendant being
objection?
charged for this.
I have no issue with the,
Same as the last one.
correct, with the information.
So no objection to taking judicial notice of the file, however, not of the actual report, of the bond violation report just yet. Let her take a look at it.
Yes, sir.
So again, State's one will be the actual condition of bond report.
Yes, sir. Do you recognize this? Yes. Yes. What is this? Bond violation report? Can you please tell us what the bond violations were in this case? Yes. Oh, wait, let me actually refresh that. Do you recognize this? Yes. Okay, what is this? Conditions for the defendant. Your Honor, we will tender State's Exhibit 1 to defense for any objection regarding the bond conditions in this case.
Judge, this says that she, oh, never mind. I misread that. No objection.
State offers State's Exhibit 1 into evidence.
Okay. Will be
Ms. Giles,
admitted.
can you please tell us, thank you, Your Honor, sorry. May you please tell us what the bond conditions are listed in this case that Defendant Lynch was supposed to abide by?
So December 3rd of 2024, we have defendant to appear in court on time every time the case is set on the court's docket unless judge waives the appearance. Defendant shall commit no new crime or shall not engage in any conduct that could result in his or her arrest. The defendant was required to obtain a portable alcohol testing device that same day, December 3rd, to submit to random drug and alcohol testing, to not consume any drugs or alcohol. And yes.
These are pretty standard for this kind of case, correct?
Yes.
Thank you, ma'am. So regarding what's been marked as State's Exhibit 2, what is this?
A bond violation report.
Does this fairly and accurately depict a bond violation report?
Yes.
State tenders defense for any objections.
I would just object to, in this State's Exhibit 2 bond violation report, there's a reference to a number of skip tests. There's no dates on here, so I'm not quite sure which ones, based on the 4 corners of the document, we're addressing.
Okay, I guess we'll be getting into that now.
Right, yes,
But-
sir.
Okay,
State offers State's Exhibit 2.
okay, it'll be admitted.
Ms. Giles, can you please read what the violations were that are overtly obvious in this case?
The client was ordered conditions of bond that included to refrain from alcohol consumption, to obtain and be monitored by portable alcohol testing device, and to comply with required monitoring, testing, service recalibration protocols. The client was instructed to not obstruct the camera on the device and do not skip any testing windows, 5 a.m. to 8 a.m., 5 p.m. to 8 p.m., 10 p.m. to 12 a.m. Blow into the portable testing device 3 times a day in accordance with the blow schedule to ensure compliance with the ordered conditions. There was a high breath alcohol content of 0.03 on 1/10 of 2025 at 10:38 p.m. The client blew into the device in the dark and her face was not able to be seen. The client failed to clear the high breath alcohol content in the allotted time. The client is also not blowing into the device as instructed. The client has a total of 15 skip tests.
And tell us what your role is in the courtroom,
A judicial liaison officer.
and you're able to testify to the bond conditions and to the bond violations.
I can testify to the bond conditions. I did not generate the bond violation report myself.
But can you attest to these dates in which the violations occurred?
I have not looked over the report recently, so I don't want to say yet.
But this is the bond violation that you've seen before.
Yes.
Okay. And it is true that the defendant here is on bond in County Court 11-5.
Yes.
I'm sorry, go ahead.
We pass the witness.
Okay. Ms. Giles, part of your job is to read the reports when they come in from the case managers,
Yes.
and then you file the bond violation report.
No, they filed the bond.
They file the bond violation
Yes.
report, and then you coordinate the,
Yes,
that with the judge?
action and the
Okay.
review of it, yes.
okay. Are you able to verify the information in the report?
If I have the report, which I should in my email, if
Okay.
I take a look over it, yes.
Okay, but the only way you can verify the report is from the report itself.
Yes.
Okay, so you have no personal knowledge of the machine itself?
No,
You have no knowledge of the software
no,
and no knowledge of how the hardware and the software work together?
no.
Okay, no further questions.
Okay. Anything further? The witness?
No, Your Honor.
Okay. So she has the first violation, right? This is the second time we have a bond violation, right? And the first one, was it that she just didn't get the device? Right?
Yes, that's when we were going back and forth on the dates to get it, and we kept resetting the case because she said that she was gonna get it and then she didn't, and then we were gonna revoke her, but then she didn't come to court, so then we sent her again, and then she didn't get the device that day, so then we gave her another chance.
Okay.
And
All right.
Judge, just, I don't think I represented Ms. Lynch the whole time on that, but I think some of the confusion was she was ordered to get the in-vehicle interlock and she didn't have a card.
But you did come at the time to where
Yes,
she
correct.
did get the device
Yes, and then
within,
once Ms. Lynch because I believe the vehicle was damaged in an accident and she was hoping to get the vehicle out and get it repaired. And when she realized that wasn't going to be possible, she got the portable device.
My car's fixed now.
Yeah.
I started getting.
Okay, we'll get to that in a minute.
my concern is that it continues to happen. What am I supposed to do?
And there it is, the moment every defendant dreads. When a judge says, "I'm revoking your bond," it means jail time starts immediately. Notice how the judge isn't angry, just firm. It's all about accountability. This is usually where opinions split. Some viewers feel sympathy, while others believe the system's been too lenient. What's your take? Is this fair justice or too harsh of a consequence?
If I let you go, I'm telling you the behavior is okay for you to do. It's not. We have court orders. You're supposed to follow court orders. You're doing what you want to do. That's not the way it works. Look, this isn't, I'll let you talk with your lawyer, but it's there. It's continuing to happen. You're skipping and you're continuing to consume alcohol. I'm sorry. I'm going to revoke your bond, man. She goes with you.
Judge, maybe
Go back and I'll talk to you.
Anything else?
Judge, since she does have a vehicle, if she makes the new bond, can we switch her from the portable to the in-vehicle?
Yeah.
Okay, thank you.
Judge, I have 2 on the docket. It looks like one is going to work out. Natalie Garza looks like it's going to work out.
Okay.
Once we get restitution established, that one should be dismissed. But we're just not there yet, but we're all in agreement.
Okay.
We just need to make sure that the number is correct.
It's kind of old though, and we've had the restitution, $500 restitution in class for dismissal since January.
We're just waiting to get the proof of the insurance from the complainant. I called twice just now and I'll call again this evening to see if I can get a hold of that today.
I'm gonna roll it a week.
I'm cool with it. We're in agreement, Judge, so a week is fine.
Got it.
And hopefully if they can get it earlier, we'll get it in earlier and she doesn't have to appear. And also, Judge, I understand that Tristan Smith needs bond conditions for the second case, so I'm here to approach on Tristan Smith.
Come up, Mr. Smith. We didn't do conditions on it?
Oh, we did. Victoria said,
Condition.
I think we're good.
Tell me, how are things going? Great. Okay. That's the best news I've heard all day. Really.
They like unenrolled me in Channel, but I wasn't gonna be able to go to Channel anyway because it's too far of a commute. So
Yeah, that's crazy.
yeah, so they just enrolled me in Humble High School. So my first day will be Thursday.
Knowledge is power. When you know things, you can do anything. I'm telling you, ask him. When you have knowledge and when you know things, it can take you so far in life. The only way you do it is by doing school, taking it seriously, and not letting other people drag you down. Because that's what you constantly have is people around you trying to bring you down. Don't let them. Be stronger. Right here, that's where it starts. When you see someone trying to take you down, even though, hey, let's go out, let's do this, it's bringing you down. Don't let it. Be stronger. Be strong-willed. Make something of yourself. And it starts, prime example right here. He's amazing, right? That's a great role model right there. You ever need anything, that's who you follow. We have things here that we can help you out too. What conditions do we need?
I thought that we needed
Yes, you
somebody.
do. Do we?
Do you want me to go over the ones that we have?
No, I mean, I think that the only thing we need is just stay in school, get a job. I would prefer you stay in school, get as much education as you can, so you become someone, go to law school. It's an amazing field. I'm telling you. Okay. I mean, I think we're good,
Yes, sir.
just don't pick up any new cases. Be good. Okay. All right,
Thank you,
friend.
Judge.
Mr. Garza, you're charged with driving while intoxicated. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
Yes, Judge. On January 26, 2025, the officer was dispatched to a crash that occurred at 10200 Beaumont Highway and observed a white Chevrolet Blazer with minor front end damage and both the driver and passenger side airbags deployed. The officer observed a male leaning against the rear passenger door of the vehicle, and when speaking with another officer, the other officer advised he observed the male exiting the driver's side of the motor vehicle. The officer observed no other individuals in the immediate area of the crash, and the officer made contact with the male, now identified as the defendant, and noticed a strong odor of an alcoholic beverage, watery bloodshot eyes, slurred speech, and wet stains on his shirt consistent with the smell of an alcoholic beverage. The officer also observed the defendant swaying, staggering, and stumbling while speaking. The defendant advised he was coming from the flea market and was en route to his home. When asked how he crashed, the defendant stated, "I was driving and I crashed. I don't remember." The defendant also advised he ate at a restaurant and drank beers there. The defendant stated he had 4 to 5 Modelo beers at the flea market, and the officer observed a cold red cup in the center cup holder of the motor vehicle with approximately a quarter of liquid inside that smelled like tequila. The red cup had 2 limes inside. Standard field sobriety tests were then administered. When asked to perform the walk-in turn and one-leg stand, the defendant refused, and the officer found 4 out of 6 clues on the HGN. The defendant was read the DIC and refused a breath sample. A blood search warrant was signed and executed.
Mr. Garza, I'm going to find that there's probable cause to go forward with the case. I would hope that you recognize it's elementary, that you're not to have alcohol in the car while you are driving. In fact, it's a minimum of 5 days in jail to any sentence that you get upon proof of that. I don't know what your immigration status is, but if you're not in this country with permission and you go to jail and immigration finds you, it's very possible they put an immigration detainer on you and you will be stuck like Chuck in custody until the case is over with and then shipped off to immigration. I am now putting bond conditions on you. If you violate these conditions, I will revoke your bond and put you in jail. And like I said, if you're not in this country with permission, you could be sitting in there for a very long time. I'm ordering you not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or any illegal drugs, you will go to jail. I'm also forbidding you from driving. You will be signing with me today a promise. This is an affidavit that you're not going to drive. I don't care what is going on in your life. If I find that you do, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you drive. Do you understand?
Yes, sir.
I'm going to have you come up here, swear to us that you're not going to drive. After that, I'm going to get you to Victoria, where we'll have you sign a reset. And after that, I'll get you to Felicia for your bond conditions. Be careful what you do, because like I said, any of these conditions, I'm just going to lock you up. Do you understand?
Yes, sir.
You were charged with driving while intoxicated, second offense. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On
Dice,
On January 27th, 2025,
2025,
on 11402 North Houston Road, the officer observed the defendant stopped in the intersection facing northbound. The defendant was observed to be asleep behind the wheel of the vehicle, which was running. The gear shift was in drive, and the defendant's foot was on the brake. Multiple attempts were made to contact the driver. None were successful. Houston Fire Department and Emergency Medical Services were contacted, and the vehicle was locked, but responders were able to unlock the doors and put the vehicle in park. The officer observed a strong odor of an alcoholic beverage, bloodshot eyes, and glossy eyes. Standard field sobriety tests were performed back at the station. HGN 4 out of 6, walk and turn 8 out of 8, one leg stand 4 out of 4. The defendant was read the DIC and consented to breath. The results were 0.186 and 0.194.
How many prior DWIs does this gentleman have?
He has one prior, Your Honor.
Have you run an NCIC
Yes, Judge.
license?
I'll run that right now, Your Honor.
No. No. Said no.
No.
He said he doesn't have a license.
Yes, Judge, there's no license on
He said no
file.
hay licencia.
Mr. Mazariegos, let me make something perfectly clear to you. That I'm ordering you as a condition of your bond not to drive any vehicle. I don't care what is going on in your life. I don't care if there's a burning building and you have to save 50 children. If you do not have a license and liability insurance, then you are not allowed to drive. I am now placing an additional restriction on you that I'm going to have you take a portable breath test device with you everywhere you go to prove to me that you're not consuming alcohol. If I find that you consume alcohol, if I find that you use illegal drugs, I will revoke your bond. I'm going to put you in jail. I don't know what your immigration status is, but if you're not in this country with permission and you go to jail any more than 4 hours, immigration sweeps the jail on a daily basis. They will put a detainer on you and you will sit there until this case is over with and then shipped off to immigration.
Una migración.
Do you understand?
Lo entiendo. Conteste palabra. Lo entiende? Yes.
Signing a promise with me that you're not going to drive. I don't
A mí.
care what you're doing. Do not get into a car.
Okay, yes.
I'm sending notice to the Department of Public Safety that every officer in this state will know if you were in a car driving, you were supposed to have an interlock in that car. If they catch you driving a car that doesn't have an interlock, they're going to arrest you and put you in jail.
Tiene el almacenamiento, van a estar in the slide.
Sí, yo no voy a tener carro ahorita.
I don't have a vehicle at this time.
La máquina portátil está bien.
The
Don't
portable
use anyone else's car
el vehículo
don't-
de alguien más.
at all.
Okay.
I'm going to have you come up here, swear to us that you're not going to drive. After that, I'll get you to Victoria. We'll have you sign a reset. After that, you'll get with Felicia for your bond conditions. Mr. Mazat, sir, do you have are you working now?
¿Estás trabajando ahorita?
Sí,
Yes.
What do you do for a living?
relación.
Remodeling.
Is that a steady income for you?
¿Trabaja todos los días?
Sí,
Yes.
Do you have the ability to hire a
¿La
lawyer?
capacidad para ocupar tu propio abogado?
sí.
Yes.
Okay, we will give you time, sir. So I'll have you come up here with all the appropriate documents and then we'll get you out of here. Do not consume alcohol and above all else, do not drive.
Aneta.
Okay? Come on. Good morning, Mr. Martinez.
Good morning, sir.
So you're charged with two cases. You're charged with terroristic threat. You're also charged with assault of a family member. Looks like you guys have worked out an agreement where they're offering you a 13-month deferred. That is a type of probation that if you successfully complete it, you do not end up with a conviction.
This next moment is one of the most powerful teaching points you'll see in courtroom footage. Judge Fleischer isn't just handing down a sentence, he's delivering a lesson. The way he explains the emotional and legal impact of family violence highlights just how fine that line can be. You don't have to throw a punch to face a felony charge. This is Courtroom Education 101, and honestly, more people need to hear this before it's too late.
It was dismissed, doesn't get dismissed. You mean you take a probation. If you complete it successfully, you don't end up with a conviction on your record. This is extremely important. The other thing that you need to understand is that with this case, there's an affirmative finding of family violence. Shh, there's an affirmative finding of family violence.
Yes, sir.
You ever pick up another case like this, you will be looking at a third-degree felony, a minimum of 2 years in prison, a maximum of 10 years in prison. And it doesn't have to be something where it's a dragged-down fight where there's fists and this. No. All you have to do is squeeze someone's arm enough to where it hurts. Boom, you're looking at a third-degree felony. You understand?
Yes, sir.
It's any pain. Pain is a very loose term. It's not what you think, it's what the other person perceives. You understand?
Yes, sir.
Now, for you to complete this successfully, you must do what's called a TRAS, which is an evaluation to see what conditions you may need. You must do substance abuse treatment. You must also do what's called a BIP class. That's a Batters Intervention Prevention Program. This is a difficult one. You have to go and do a class once a week for 18 weeks. If you fail to appear for the class, they're going to kick you out and I'm going to issue a warrant for your arrest. 16 hours of community service, no threatening or harassing abusive contact with a Mr. Pipkins, no drugs, no alcohol, $100 donation one time to the family violence. It says family violence provider, or should it be?
Center, Judge. Father means center.
Should it be the Houston Area Women's Center?
Let me see, Your Honor.
I've never heard of.
I mean, it's just language that would include things like Houston Area Women's Center or any organization.
Okay.
I do need to work on wording.
Yeah, I've never heard of that. So if
Houston
It's
Area
just-
Women's Center, Judge.
Yeah, any
can you put it to
organization.
Houston Area Women's Center? No weapons as well. I'll make you a deal. I would prefer him to do a class instead of the 16 hours community service. So perhaps like a effective decision-making class in lieu of that at his choice, if he would prefer to do that. A more menial tasks, picking up that's just, it makes no sense. I'd rather you learn something from this, and like an effective decision-making class is something that you can do at your leisure instead of just doing menial work that just makes no sense.
Thank you, Your Honor.
And I'll make you another deal, Mr. Martinez.
Yes, sir.
If you're clean, if you're nice to everybody, you get your classes done quick, I'll take you off in half the time as a reward for you doing well. But I want you to understand, if you pick up a new case, if you don't do your stuff on time, if something else happens, I'm going to issue a warrant for your arrest. I'm going to put you in jail. You were looking at an entire year if you violate this probation. Do you understand?
Yes, sir. Thank you, sir.
Well, it's not hard. 90% no self-control. That's why they're in custody. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So once you enter into this agreement with us, you are stuck with us until you complete it or unless it gets revoked. Do you understand?
Yes, Your Honor.
Now, like I said, as an added incentive, you can be done with this thing in 7 months if you do really well and kick butt. All right?
Yes, sir.
How do you plead to the offense? Guilty or not guilty?
Guilty, sir.
I will not find you guilty. I'll withhold it for 13 months. So you work at PetSmart.
Yes, sir.
It reduces fees. All right. It's never about the money. I don't care about the money. So don't worry about the money. Just do what you say you're going to do. Be nice. Don't pick up any new cases. All right?
Yes, Your Honor.
All right. Good luck, Mr. Murphy.
Thank you, Your Honor.
Thank you, Mr. D.
Yes,